Pariksha, and today we will continue from the last video. So in last video we have done till here, like we explained this roadmap of filing a patent file, and today we will now start with the other information related to patent applications. So what are e-filing facilities available at IP India? So we just need to remember 2 points here are that is there is 10% fee reduction on online filing period compared to offline. Like if you file online, you will get 10% off. And request for expedient examination जो होता है वो only through e-filing के ही होता है. Like request for expedient examination will be done only through e-filing. Now there is no more from here onwards we have only few points that need to be remembered, and I will try to finish the whole video today. Like if that doesn't exceeds 11 minutes. Now is there any difference in the amount of fees to be paid by an individual or a legal entity for a patent filing application? So yes, the patent rules provide different fees for individuals and startups, small and medium enterprises, and legal entity. Now you should remember, like there is a separate fees for legal entity and SMEs and startups and individual. There is no uh, same fees for them, no prescribed same fee, and details can be seen on the first schedule of patent rule 2003. What are obligation of the patentee after grant of patent? So after the grant of patent, every patentee has to maintain patent by paying renewal fee every year as prescribed in the schedule 1. So I told it this earlier as well. After the grant of patent, you have to pay the renewal fee every year, and it is prescribed in schedule 1 of the patent act. And for the first 2 years there is no renewal fee, because after 18 months it gets public, so there is no renewal fee, but the renewal fee will be payable from third year onward, and in case of renewal fee is not paid, the patent will be seized. So remember this as well. Now, can the patentee pay the renewal fee at the time or has to pay every year? The patentee has a choice to pay the renewal fee every year, or he can pay the whole amount in a one go. Now, when can a patentee pay when can a patent be restored after its cessation? A request for restoration of patent can be filed within 18 months from the date of cessation, and a patent along with prescribed fee. So it doesn't like mean here like when you forgot your filing, paying the renewal fee of your patent and it got seized. Now anytime you will come and pay the renewal fee and get your patent again active. Within 18 months you have to pay the patent fee, else your patent will be deemed to be seized. So the 18-month timeline is important here. So what is meant by patent agent and what are the eligibility criteria of becoming a patent agent? The patent agent is a person who just simply become a bridge between the individual or entity and between the QCI or patent office. So now, after being declared as a patent agent examination, there is an examination conducted for patent agent, and whoever clear is, they are like declared qualified, and he has to he gets a power to practice before the Controller General of Patent and to prepare all document, transact all business, discharge such other further as may be prescribed in connection with the proceeding before the controller under this act. Now eligibility conditions. So he should be citizen of India. He has completed 21 years of age. He has obtained a degree in science, technology, or from any university established under law in force of territory of India. And in addition to these, he should be pass the qualifying examination, and has or he has practiced for a total period not less than 10 period, functioned as in if he hasn't passed the examination, then he should have practiced or he has been a officer in the patent applicant for not less than 10 years, functioned either as examiner or discharged or the function of controller under section 73 or both. Cease to hold license. Now, is it necessary to engage the registered patent agent? filing an application for patent? It is not necessary. Like not, it is not necessary for you to come up with a patent agent then file an application. It's not like a court that like you have to hire a lawyer anyways. You can come by yourself as well. No, is it mandatory to obtain prior permission from patent office to file application for patent outside India or abroad? So ordinary under following circumstances, it is not necessary to obtain prior permission. Like the conditions are: application is not applicant is not a resident, Indian resident, and invention is originated abroad. Neither applicant nor invention is invented in India. And if the applicant is an Indian resident and filed a patent application, has been in India before filing the application outside, and the 6 week period is over from that date. Now, if 6 week period is over after filing the patent application in India, then he can file the application abroad. And the invention does not belong to atomic energy or defense purpose. And if the invention doesn't belong to this category. Now, under what circumstances it is necessary to obtain a prior permission from the patent office? So residents of India require permission to apply for patent outside India under Section 39 of Patent Act of 1970. And the conditions are: the applicant or inventor is Indian resident. Applicant does not wish to file patent application in India prior to filing outside India. And if the applicant is Indian resident, a patent applicant application has been filed in India and 6 week period is not over yet. Now, like we have talked about 6 weeks period. Now, if you have filed the application of patent in India like 1 week ago, now you want to file it outside. So you have to take permission if you are filing it before the 6 months. Now, the invention relates to atomic energy or defense purpose. It is straightforward now. Like, however, the invention is relevant for defense or atomic purpose, no permission shall be granted without the consent of such government. If your invention is related to these, you have to take permission of central government, not from the patent office. Now, is there any additional requirement for filing of patent application in respect of microbiological invention? So yes, in addition to various forms required to be filed at the time of filing patent application, the applicant has also required to submit his microorganism in a recognized depository, which assigns a registration number to the deposited microorganism. And before filing of the patent application, this number needs to be quoted in the patent application. Now, are there any specific instruction to inventors in respect to filing for patent application where their invention lies in biological material? Yes, the Patent Act 1970 as well as Biological Diversity Act 2002 stipulates that the source and geographical origin of the biological material should be clearly disclosed in the patent specification. And further, according to provision of Section 6 of the Biological Diversity Act, if the biological material is used as invention is from India, permission from the National Biological Authority has to be obtained, and the same should be submitted to the patent office before getting grant of the patent. Is it essential to deposit biological material in an international depository authority? Yeah, if the invention uses biological material which is new, it is essential to deposit the same in the international deposit authority. And they will give you some description, and the description will be it will contain the specification, and the specification will be name, address of the international depository, date and number of deposition of biological material, like a reference number. If such biological material is already known, in such case it is not essential to deposit the material. Now, is there any international depository authority in India? Yes, there is an international depository authority in India located in Chandigarh, which is known as Institute of Microbial Technology (MTech). Now, under what circumstances fee can be refunded? So, fee is refunded for only the newly inserted rules of 4A provide that in case of withdrawal of patent application for which request of examination has been filed but first statement of objection has not been issued, then 90% of the fees for non-expedite or expedite request of for examination may be refunded to applicant if he/she requests in newly inserted form 29 which requires zero fees. And if the first examination has been done and FER has been issued, then there will be no fee refund. Now, what are the changes made to submission of power of attorney? The deadline of filing a power of attorney is 3 months from date of filing of patent application and failing to which no action will be taken. So these are the timelines that you have to remember. I will come once I will complete this video. I will upload this marked PDF on my Telegram channel. Link is in description. Now, what are the instructions to patent agent regarding submission of all documents by electronic transmission? So now patent agents are required to submit even those documents by electronic transmission that need to be submitted in original. That is through scanned copies and then mandated to submit the original document within period of 15 days. So before filing the patent application, patent agent need to submit all the documents like complete documentation through the scan copy to the patent office, and within 15 days they have to come up with the original copies to the office. Now, is there any scheme available for MSME startup with respect to IPRs? So yes, the government of India has formulated a scheme to spur the innovative capabilities of innovator. So for MSMEs, there is a 50% concession provided for MSME vis-a-vis a large entities in filing patent. And the cessation was provided by the means of a scheme for facilitating startup intellectual property protection. So you should remember this scheme SIPP, like it is for facilitating startup. And now, what is the criteria for the startup to get this scheme? So startup should be registered in India under the Startup India Act initiative of Government of India. Now, what are the benefits of providing Government of India to startup application for filing of patent application? So, entity qualifying as a startup and stand up India initiative, Government of India can avail the facility of expedite examination. So, all the entities which are registered under the SIPP, they can also register the facility of expedite examination, and the government reimburses the expenditure to the facilitator, like and the startup for filing the prosecuting of patent applicant to extent of 10,000. Now government will even refund the amount you have paid to the patent agent till 10,000 to boost the startup and to like motivate them. So from here now we will discuss from in the last next video.